and welcome to the CEI Book Club by the Climate and Environment Initiative at RSIL. Today we have the pleasure of being joined by Dr. Birsha Ohdedar. Dr. Ohdedar is a lecturer in climate change and environmental law at SOAS University of London. Birsha's current work focuses on environmental and climate justice, human rights, climate litigation, and water. Birsha works on these issues at the international and domestic law level with a regional focus on South Asia. Prior to his academic career, Birsha practiced as a lawyer in law firms and NGOs in the UK, India, and New Zealand. In 2021, Birsha authored a chapter titled Climate Change Litigation in India and Pakistan, analyzing opportunities and challenges in the book Climate Change Litigation, Global Perspectives, edited by Ivano Alogna, Christine Bakker, and Jean-Pierre Gauci, and published by Brill. Thank you so much for being with us today, Birsha, and over to you for your general comments on the chapter.
Yeah, thank you. Thank you so much for the kind introduction and for the invitation. Firstly, yeah, it's my pleasure to be here today. Yeah, I guess in terms of the chapter, it's a part of a sort of book edited volume with a number of chapters looking at different climate litigation at different around different countries, as well as at a regional level, such as in the EU or in the African context, etc. The wider context, in a sense, is that in recent years there's been a sort of flurry of climate litigation. The kind of often quoted statistics is that since 2015, we've seen a doubling of the amount of climate litigation from what preceded it in the last 30 years. So between 1986 and 2015, there were about 800 recorded cases. And since 2015, which was the year that the Paris Agreement was signed, there's been about 1,000 cases. While in the global south, in developing countries, it's still sort of less than what there has been in the global north, there is now an increasing trend of cases being filed in the south. And so there's increasing interest in countries in the global south, such as India and Pakistan. And this is particularly the case in terms of Pakistan because of the Asghar Leghari case. And some cases get talked about more than others in terms of climate litigation, and that is one which really hit the headlines when it came out. So this book was kind of, as I said, a compilation of different perspectives from around the world. It arose out of after there was a seminar on climate litigation just before the pandemic in 2020. And so this book was sort of written after that, and bringing together NGOs, lawyers from NGOs, academics, judges, and so on. So it sits alongside other chapters which explore litigation in Brazil, in South Africa, in Australia, in France, in the UK, and so on. So that's kind of where the context of this chapter sits. In terms of my chapter itself, it looks at India and Pakistan, climate litigation in India and Pakistan, which we'll talk about shortly. At the time I wrote it, because of the Leghari case, there was a lot of interest in both Pakistan and South Asia or India as well. But the analysis at the time I felt was still a little bit superficial in terms of how Leghari was being talked about, in the sense of it created a bit of quite a lot of excitement, but to some extent kind of glorified this case as some sort of massive breakthrough. I know in your last podcast you had Asghar Leghari himself in the podcast, so I was listening to it, and it was actually very interesting to hear that he was talking about that as well, that kind of exoticized his position as like a farmer that from the global south who brought this case, when in actual fact his socioeconomic class was quite different, etc. So I kind of wanted to bring together some thoughts on litigation in India and Pakistan, the potential for climate litigation in India and Pakistan, but considering it within the sort of broader political economy of South Asia, the political economy of climate change, and so on, rather than just simply talking about these cases outside of the political context that they they operate in.
Absolutely. And I think that discussion of the political context as well is very necessary, because most of these cases come preceding or after an international conference, after a country has made commitments on an international level or produced certain policies. So that context can't really be removed from the discussion. So I'd like to ask you to expand a little on why India and Pakistan are seen as such locations for climate change litigation. You discussed public interest litigation and the history of an activist judiciary. Could you explain a little bit more about that?
Sure. So the courts in India and Pakistan are, in a sense, have been quite unique, and have been kind of for the last 3 decades or more kind of talked about around the world in terms of its jurisprudence around human rights and environmental cases. And part of this arose in the 1980s in India, in the aftermath of the emergency, when the constitution was suspended by Indira Gandhi. The courts kind of, amongst other things, sort of upheld some of the most draconian aspects of that period. So in that aftermath, there are various explanations for why the courts then suddenly, once in the 80s, so in the decade after that emergency, it then adopted a much more progressive stance. Some saw it as kind of making up for the sins of the earlier decade and so on. That's a separate debate, not for right now. But in this context, nonetheless, the court began to relax many of the rules or the procedural requirements for how people brought cases. So standing rules were transformed. It allowed people to bring a public grievance on behalf of any person or any sort of wider cause or so on. Because of the relaxation of standing rules, anti-poverty campaigners, environmental activists could bring claims based on the larger public good. So I could bring a claim based on the larger effects of pollution and didn't have to show exact impacts on myself or show direct harm on myself. So that allowed, NGOs and so on to bring claims, which was a big thing, and it kind of was seen as sort of democratizing the courts, removing them from being sort of elite spaces and allowing a lot more people to access the courts. There were other flexibilities too that were important. So the courts could pick up claims even when it wasn't based on sort of formal procedures to lodge claims. A letter to the court could be enough. The court could just take up a case by itself and so on. And that was in India, and in Pakistan in the early 90s sort of adopted a similar model, and environmental litigation started to take hold in India, Pakistan, also Bangladesh, and through South Asia in this kind of similar way, where these procedural hurdles that we face in the global north were no longer kind of seen as hurdles in South Asia. And you started seeing environmental litigation for all sorts of things that you hadn't seen before. So there were the first public interest litigation in India was a claim in the 1980s by an NGO that wrote a letter to the court about mining practices in northern India, in Uttarakhand. Similar practices around pollution from tanneries, gas leaks, and so on started coming in. So all of these things meant that there was all of these judgments, and more importantly, the judiciary was really not afraid to step on the executive's toes. So that means that the judiciary was taking policymaking into its own hands and issuing judgments, really pushing the government to do something about certain issues. So I guess linking that back to climate change and climate litigation, because of all of these judgments for the last 3 decades or so, because of this kind of rich jurisprudence, we've had a lot of excitement around India and Pakistan as potentially being, because of this sort of litigation, that being a place where it could be perhaps quite fruitful for climate litigation to take hold. This is because historically climate litigation has had problems of standing. So how does a particular person bring a claim based on some wider common environmental ill like climate change? causation. How do we prove that a cyclone or a drought, is caused exactly by climate change or something else? And human rights as well. Human rights has been much more narrowly interpreted in different parts of the world. In India and Pakistan, there's been no issue that there's been a right to environment, a right to water, a right to various other social, economic, and environmental rights. And also the judiciary and the executive relationship. So the judiciary has not been afraid, as I've said, to really push the government into doing something about a particular problem. So in theory, it means that there was a sort of unique ground for this kind of litigation. And, the Leghari case, which your previous podcast kind of focused on, is really kind of, is that, right? It kind of is the judiciary really pushing every single part of the government into coming up with a more robust climate plan. And it was framed in rights-based language as well. So it kind of really tied all of those things together. So in that sense, that these are the reasons why I think, in South Asia has been seen as a kind of place where climate litigation could really take hold. But I think at the same time, there is reason to be a little bit more nuanced, a little bit more critical, skeptical perhaps, about what it can or what it can't do. I think it can certainly provide some headline cases like the Leghari case. And that's not to say that the Leghari case is just a headline. It's a really seminal and important case, etc. But it's the way it kind of is portrayed sometimes is that it will solve all everything, etc. And again, as the petitioner himself in your previous podcast kind of reflected on some of the challenges of such litigation. But there, as I was saying, more broadly, there are a lot of issues with this kind of litigation or what has happened in the last 3 or 4 decades. So just to kind of expand on that, firstly, in terms of impact, you may get a nice decision but on paper, but how does it impact on the ground? Petitioners often have to go back and get further orders and so on to actually see the implementation of what the court has said. So it doesn't stop at the nice decision that we can read as lawyers or legal researchers and so on. To actually have the implementation on the ground, it takes a lot more work and often doesn't actually amount to much. Secondly, in a similar vein, the court may ask the government to change a particular policy, and that's what in Leghari they did that, and so on. And the government may do that, but in South Asia, or at least in India, I should preface this whole podcast by saying my main focus, research focus, etc., has been in India. So I don't pretend to be a specialist on Pakistan. I just picked it up in this particular chapter because there are some crossovers in terms of litigation. But as I was saying, kind of producing policies has never been an issue in South Asia in terms of producing really well-meaning, well-written, or well-written at least, policies. The bureaucracy, the Indian bureaucracy, is very adept at producing nice policies. But it's again that implementation that may lead to transformation that is an issue. And then the decisions themselves, I mean, we talk a lot about the good decisions or the progressive ones, but there are a lot of regressive ones as well. There's a tension in terms of environmentalism in the courts, in terms of what kind of environmentalism. So often we've had decisions in the Indian context, at least, where environmental issues have been perceived very narrowly to favor certain class interests. So what I mean by that is, for instance, the beautification of cities is seen as kind of an environmental issue. So the demolition of slums to make cities, especially big metropolitan cities, more green is seen as something that environmentalists take on, an environmentally progressive kind of thing to do, but it's actually obviously at the detriment of significant social justice and human rights issues. Similarly, there's been a preference for urban environmental issues rather than rural environmental issues. Again, because the judges have such a sway in terms of which issues get heard, how they get heard. judges are often have biases around these issues as well. And then large infrastructural projects are often kind of preferred. So things like dams, for instance, we can come on to talk about dams later, but even in Pakistan, you've had cases where the courts have been very enthusiastic about large dams, crowdfunding large dams and so on. And in India, they've done similar things in terms of overlooking some of the livelihood concerns around dams, environmental concerns around dams. So there are all of these kind of issues around, and sorry, lastly on that, there's also the relationship between the executive and the judiciary, which has changed, or the government and the judiciary, which has changed a lot in India, and I'm sure in Pakistan as well, in terms of being kind of, there's always a tension there between what the judiciary can do and can't do, because for instance, in India, the National Green Tribunal, which was set up in 2010, has since then, once it started issuing judgments, which maybe the government didn't like or so on, it then slowly got disarmed by judges not being appointed and so on. The relationship between the center and the courts has also been under scrutiny since the current Indian government has been in place, a kind of hardline right-wing government. So the Supreme Court has not been as progressive on many issues when it's been asked to step up. So all of these things mean that I think some of those theoretical underpin, not theoretical in a theory sense, but in terms of the kind of the lack of procedures and things which might mean that there are more climate litigation cases in India and Pakistan, whether they actually lead to really kind of progressive things on the ground, we have to be a little bit more nuanced and think through whether that is the case, and not just stop at reading a case, reading the case as it's laid down.
In Pakistan, one of the issues that has been highlighted by practitioners is that when you go to the court with a climate change case, the results you can get can vary vastly based on the bench that is hearing the case. So is that similar in India as well?
Yeah, absolutely. And I think, and this is kind of the one of the issues, and it's really has been critiqued a lot by more recently in terms of academics and so on. But the lack of, in a sense, precedent laid down by the court in terms of reasoning that's used for particular decisions means that often you have judgments which depend a lot on a particular judge having a particular viewpoint, or the side of the bed that the judge wakes up on, essentially. He wants to rule one way or the other. So the lack of those kind of procedures, the lack of those kind of court etiquette, the court, lack of sort of legal reasoning, lack of means that there's some people call it judicial populism, in a sense that the judiciary just or the judge just does whatever he or she wishes to do on the particular day. That causes a huge issue, as I pointed out, in terms of the types of judgments you get. So you may get some progressive ones, but you'll equally get a lot of regressive ones. And yeah, so for when we talk about environmental justice, climate justice, and so on, yeah, there's an issue of kind of understanding these issues fully as well. There is now a bit more emphasis on training judges on these issues. However, I think it would be good to see more training, not just on the science of climate change, for instance, but also on some of the justice implications of climate change. So in terms of the social justice implications and so on, so that judges as well as lawyers are much more informed on the issue in a more holistic way than just thinking about it in terms of the science.
Mm-hmm. And that's something I'd love for you to explain a little bit more. This idea that when we focus on a narrow view of climate change, and specifically on emissions reduction in India and Pakistan, then it can divert attention from the social injustices and environmental damage. And one thing that I found very interesting in your chapter was that you wrote about, you cited research about how bureaucrats can use this idea of being climate positive to actually support the kind of big infrastructure projects that they would have supported anyway. They just have a reasoning and justification behind it now.
Yeah, thanks. That's an interesting question as well. Yeah, this kind of goes, so I touch on this in my piece because, I mean, in a book chapter, it's hard to put everything in, but I thought I'd kind of highlight this issue. It really goes in terms of, firstly, in terms of emissions and clean energy projects, this really goes to the heart of the issue of just transition. So actually, while we talk a lot about climate change, and as I was saying, in terms of educating people about the science of climate change, we actually need to talk about climate justice and just transition. Just transition is the idea that as we transition to a kind of a lower carbon economy and so on, that the justice issues, the social justice issues that arise are also looked at, whether it's in terms of workers that work in fossil fuel, so coal mines and so on, or in terms of when clean energy projects are undertaken, that we think about the environmental and social consequences outside of just concentrating on climate in terms of carbon. And countries like India and Pakistan are going through a lot of transition right now. So India and Pakistan have both put forward at least very ambitious mitigation commitments around renewables. India has put, I think it was 450 gigawatts of renewables by 2030, as well as a net zero target by 2070. Pakistan, I think, has said something like 60% of its energy by, I've forgotten the date now, that it wants to be renewables. It's also put forward mitigation targets, very ambitious mitigation targets. Parking to one side the kind of feasibility or reality of whether these goals get actually met, rather than they're just sound bites during a particular climate conference or something like that. Parking that issue to one side, I think even then there's going to be a lot of, there is a lot of renewable energy kind of projects going on and in the pipeline and so on, a lot of money being poured into it, a lot of private sector interest in it and so on. So that kind of energy transition will be taking place in places like South Asia. And what I wanted to highlight in my article was that if we have a very narrow focus on just carbon reduction, we miss some of the issues around social and environmental justice that arise from some of these projects. So for instance, and this is not to say that we don't want more renewable or clean energy, it's just to kind of, again, think about it in a much more holistic way. For instance, hydropower, as I mentioned, dams and so on have been popular in South Asia and are often categorized as clean or green energy, but that's highly disputable in terms of the scientific evidence as well, in terms of how much carbon it emits, but also looking outside of just carbon in terms of the environmental effects it has on rivers and water bodies, in terms of the livelihood effects it has by flooding villages, displacing people, and so on. Those get forgotten about if you're only focusing on reducing your carbon emissions and so on. And often we've seen, so I highlighted some cases in the piece where judges have use that kind of the language of green energy, more clean energy, to sideline these social justice and issues. Similarly, solar power is one which, at least in India now, you're getting a lot more conflicts around. So solar power is by far one of the cheapest ways of producing electricity. So it has a lot of potential in terms of providing a lot more energy for developing countries, but it requires a lot more land, and land which is used for in rural areas for people to carry out, small scale farming, livestock raising, and so on, which these large solar plants or solar parks are basically taking over people's land and livelihoods. So you've started to see now cases being filed, at least in lower courts in India, where it's to stop a solar power project and so on. And it's, in a sense, in terms of how the judiciary has reacted, it's pretty mixed. There have been a number of cases, which is what I highlighted, I think I highlighted in the chapter, where, again, that kind of green energy, it's green energy, so we don't need to do anything. It's all clean, everything is fine. Means that they've given a green light to project developers to do pretty much what they want and so on. But in some cases, they have been successful in at least stalling some of the projects from going ahead. So it's used by people as a tactic to at least stop that project from going ahead and so on. Even if some of them are still kind of whenever I've checked them recently, they still kind of haven't progressed beyond stalling, but at least it's provided a hurdle at this stage. So yeah, in terms of, going back to, I guess, the bigger question of in terms of what you were asking about policies and being used by government bureaucrats to do exactly what they want. So that's a separate kind of issue. So one is the issue of what I was saying in terms of the just transition issues, in terms of the courts kind of trying to look at these energy projects in terms of not just carbon, but actually having significant human rights and environmental issues beyond. So there needs to be more thought around that. But the other issue that I highlighted is that, and it's in a sense linked, climate change is quite a malleable term in terms of, you can say that I'm doing something. It's a bit like terms like sustainable development, sustainability, and so on. You can say that a lot of things are good for, climate change or good for sustainability, similar to greenwashing in a sense. So you can use it in different ways. So I guess the point that I was trying to make, and this is made by another researcher who was Matthew England. He wrote a piece on India's water policy in the context of climate change, and he talked about how there was a lot of climate policies that were India launched in the early in sort of 2009, 2010, and the water policies, the water department then had to take on some of these policies, or at least look at them. Now in India, Pakistan, and your previous podcast, Leghari also pointed this out in terms of different departments don't talk to each other often, and different departments often see their role in a very narrow way. So the water department probably didn't even consider climate change. The food department wouldn't have considered, agriculture wouldn't have considered, they just see it as this is our little domain. So when this climate policies came out from this, and they were kind of created by the center, so they were top-down policies, the bureaucrats essentially just justified, they used the term, you can use the term climate to justify different projects that you already doing. So a large dam could be like, well, okay, now we can say that this is for green energy and say that this is actually good for climate change. So you can use the term climate change in such different ways that you can greenwash, in a sense, particular projects that are going on. So again, so I kind of pointed that out in terms of litigation, which may lead to more saying that we'll have a new policy on climate, a new climate policy or something like that, may not actually lead to transformative change, because it can just be used by others just to say, just to justify things they were doing before, and say that now it's actually being done in a green way or something like that.
Mm-hmm. And then I definitely think it's important to highlight the research that focuses on holistic aspects of policies, of decisions, of infrastructure projects, to really look at it in a critical way and keeping in mind the human rights concerns, environmental concerns, climate change concerns, and of course, Pakistan and India's development concerns, because those economic development concerns are very important at this time. And I'd like to ask you now about the decision you made in your book chapter to include cases that are what you call litigating in the context of climate change. So that don't specifically have to do with climate policies, but they still produce results and progress for mitigation and adaptation.
Yeah, thanks. So it kind of all links in terms of what I was saying before. So in terms of climate litigation, I mentioned at the start around how climate litigation has exploded in the last 6-7 years or whatever. And a lot of that is how that is tracked and measured is that there are some databases that are available freely online that are done by the London School of Economics and by Columbia University. And they're fantastic databases. So I'm not at all like this is the work they do is astounding, and I know some of them, they're good friends and so on. But a lot of this sort of research and discussion around climate litigation has kind of stopped at just looking at cases in those databases, and how those databases pick up cases is if they mention climate change in some way. But what I kind of wanted to point out was that there is a lot of climate litigation which doesn't mention climate change, and there are specific reasons for that. And I'm a little bit I'm indebted here to the work of Kim Bauer, who's a professor at Durham University, and she wrote a piece titled "The Unsexy Nature of Climate Litigation," where she talks about low-level cases, mundane, smaller cases around insurance, tort law, contract law, and so on, which have climate issues buried in them. And I sort of took her argument a little bit and expanded on it in the South Asian context. And I was thinking about this for a few different reasons. One was my own experiences during my PhD, where I was doing field work in places like Rajasthan and West Bengal in India, where there was impacts of sea level rise, impacts of drought in Rajasthan, and so on. And it wasn't talked about in a climate change kind of way. And if you asked a government bureaucrat or something like that about climate change, they'd say, oh, there's no climate change here or something like that. Or they'd say, oh, that's a very technical issue, but here we're dealing with XYZ. And the XYZ was, well, it's drought, water scarcity, heat waves, sea level rise in West Bengal, and so on. So they're dealing with the impacts of it, but perhaps not framing it in that climate language. And the climate language has progressed a lot further in the global north, in the global, or at least in South Asia, in a sense, and it's catching up now. There's much more awareness about climate change now, but it's still not in the same way that it is talked about in other places. So because of that, I thought I'd bring it up, because there are a lot of cases around issues which are very much about climate change, but it's just that the lawyers or judges aren't framing it like that. And there may be reasons why they're framing that. It may be that there's a risk in framing it as climate change, because climate change still, to some extent, is understood as some sort of natural thing that's happening, that in the sense of that it kind of displaces the responsibility of the government, and it might be understood as, well, this is happening around the world. Not much the government can do about it. We've got to, deal with it in a different way. So maybe petitioners are a little bit afraid of framing it in that way, or diverting the discussion from the very immediate issues of food security, water scarcity, and so on, that are more pressing. So because of that, I kind of thought I'd highlight that, to just say that, yes, when you look in those databases, for instance, there aren't many cases from India and Pakistan, but that doesn't mean that there's not much climate litigation in India and Pakistan. There are lots of cases around things like for instance, in my chapter, I talk about a case about drought relief where an NGO brought forward a case about what the government has to do when there is a drought, the declaration of the drought, and so on, in terms of what food is given, how to maintain, ensure that children have enough to eat during drought periods, and so on. So these cases, that's very much, in my eyes, a case about climate adaptation. It changes the government's policies around drought, around responses to drought. It doesn't mention, and in 6 orders, it doesn't mention the word climate change, but it is about climate change. So I kind of tried to, that was kind of why I brought up that. And then actually I'll plug here a more recent piece by myself, where I've written in the Journal of Human Rights and Environment, an article. This one focuses mainly on India and climate adaptation litigation, where I kind of expand on the arguments that I make in the book about this issue of climate language and try and think about ways that we can think about particularly adaptation litigation. So climate adaptation is essentially, the issues that people feel when they feel the effects of climate change, not as opposed to mitigation is reducing the emissions. And why those kind of litigation around adaptation, so which is primarily things like water security, food security, and so on, are not going to be necessarily argued in the courts around the language of climate change. It may just be in that kind of language of water scarcity, food security, etc. So I try and put forward kind of a framework for thinking about how we can start to map, or at least think about the types of litigation that could be relevant from a climate perspective, and where interventions could be made by lawyers or activists and so on.
That sounds really interesting. I'm really looking forward to reading the article. And I think it's very important as well to be to have this perspective from the Global South, focusing on the Global South, because it kind of highlights those cases that would make you think that perhaps India, Pakistan don't have a lot to contribute to adaptation, when in fact there's lots of evidence to the contrary. And lastly, I just wanted to ask if there are any developments in the field of climate litigation in your research, perhaps ideas that you would have included in the book had it been written today and not in 2021.
Yeah, thanks. In terms of developments in terms of climate litigation, it's an area which is expanding really fast. So if anyone's kind of tracking developments, it literally new cases are arising all the time around the world. India, Pakistan has been, in terms of those kind of headline climate litigations, the ones which are talking about climate change or are large strategic lawsuits. There are a few of them that are pending still, so that hasn't actually progressed very much. So in Pakistan, the Rabab Ali one and Maria Khan one, which are both about mitigation, are still pending from what I've last checked. And in India, there hasn't been, as far as I know, much follow-up with there was another case in India called Ridhima Pandey, which was filed by a child activist, and that didn't succeed in 2019, and I'm not sure if they've filed an appeal or not. But in any case, those headline ones there hasn't been any kind of big new one. But I think, in terms of the taking the book chapter forward and so on, the article that I wrote, just to expand on that, the article that I wrote which was published recently in the Journal of Human Rights and Environment, but is also actually available if you just search freely on the net through research platforms. It kind of expands on these ideas that I had in the book. So I started kind of thinking about these ideas while writing this chapter. So that's why I decided to write this follow-up piece around these kind of lower cases that happen, lower in the sense of lower courts, or much more less headline-y cases, and around issues of adaptation. And I think what's really interesting there is the number of types of issues that I started to think about that are related to climate change. So one of them, for instance, was around debt. So when there's a drought, as we know in in rural South Asia, there's a huge debt kind of issue in terms of farmers being heavily indebted and so on. But areas which are experiencing a lot of drought, a lot of floods, etc. These areas, rural farmers, rural workers, etc., go into cycles of debt continuously. And then this happened again during COVID because of a loss of livelihood and so on. So I started to think about litigation around debt, for instance, and its impacts on in particular areas which might be experiencing heavy drought, and looking at those through the prism of a climate adaptation kind of prism. So if the court or if the government starts to if the court kind of pushes the government or pushes some changes in terms of how debt is regulated, how debt relief is given and so on, that is in a sense an adaptation policy, an adaptation activity, because it's people are adapting to climate change by going into debt. So if you change some of the ways that kind of debt to stop that cycle of debt, that's an adaptation policy. So there were various kind of ways that I started thinking about how we can respond to climate change, and in terms of, for instance, just transition, in terms of workers' rights and things like that, because the green energy industry is far more privatized, far less unionized, and so on. So workers' rights could be much more unjust for workers going into a clean energy sort of transition. So starting to think about those issues in terms of climate change. And again, these cases may not be obviously are not necessarily litigated in terms of climate change. So we don't have to look for the word climate change in the judgment, but if we think about the broader issue and try and think about strategic cases around this while a transition is happening or while an area is experiencing drought or something, that opens up avenues to think about climate litigation in a much more broader way than much of how we're thinking about it now, which is not to say that we don't need those strategic headline cases like Lake Hari, Agenda, and so on. Those are very important as well, but it can't be the end point of how people interested in climate change and law look at this issue. Yeah.
Thank you. And I think our audience will really enjoy looking at more of your work and deeper into these issues that are related to climate change, but don't always come into the headlines. So thank you so much, Birsha, for being with us today. It was a very interesting and informative discussion.
No, thank you. It was a real pleasure to talk to you, and really have been and looking forward to following the amazing work that you guys are doing. So thanks a lot.
Thank you.